Hello, everyone. Welcome to week 6. And well, it's week 6. Imagine that. It's just a few more weeks and it's going to be the end of the term. So this week, we're going to be talking about federalism and governance, and especially in relation to a conflict of laws. This, again, is a topic that focuses on the ongoing conflicts between the power of the Commonwealth Parliament to pass laws and, of course, the power of the state parliaments to pass laws. It's important for us to go back to the history of Australia and recall that prior to federation in 1900, the states were self-governing colonies, and they were apparently supreme in their own states to be able to pass laws. So there was no federation then, which essentially meant that state parliaments at least, didn't have to consider the possibility of a law that they pass being in conflict with a federal law, for example. And so they could practically pass any law. A state parliament could pass any law that it wished without having to consider if there were any constraints upon their ability to pass a law. This apparently changed with the creation of the Commonwealth in 1901, because then you now have to deal with a scenario where there is a Commonwealth, which has at least the Commonwealth Parliament, which again had the power to pass laws. And that meant, therefore, that with the Commonwealth Parliament being able to pass laws, there was apparently a possibility for conflict in relation to those laws, because when the Commonwealth Parliament passes a law and it applies to the Commonwealth, it must necessarily apply to states, because states are part of the Commonwealth. And so, as far as the framers of the Australian Commonwealth Constitution were concerned, they had to consider the issue: what actually happens when there is a potential for conflict between the laws passed by the Commonwealth Parliament and the laws passed by a state parliament. And as we know, and this is a very important point, as far as the vertical division of power is concerned, and we're talking about the power between the Commonwealth and the states is concerned, we know that under the Constitution, the Commonwealth Parliament's ability to pass laws is limited only to that which has been granted to it under the Constitution. In other words, the Commonwealth Parliament could only pass laws for as long as it is permitted to do so under the Constitution. Beyond that, it has no power to legislate on a particular subject matter. So in other words, in terms of the way that the ability to pass laws is concerned in Australia, the clear division of power is such that the states can practically pass any law that it wishes for as long as it applies only to its own state or territory. But the Commonwealth Parliament is limited only to those subject matters over which the Constitution has afforded it the power to pass a law. And of course, the main provision for this is Section 51 of the Australian Commonwealth Constitution. And we always have to remind ourselves that before the Commonwealth Parliament is even able to legislate on a particular subject matter, it must be able to clearly establish that the law it is passing is within a head of power, for example, under Section 51. Of course, there are other provisions in the Australian Commonwealth Constitution that does allow the Commonwealth Parliament to pass a law. For example, the power to raise armies, or the power in relation to the ability to pass laws concerning excise taxes and duties and so on. But the main basis on which the Commonwealth Parliament is able to pass laws is really in relation to Section 51. And the other key point there is that while the Commonwealth Parliament's ability to pass laws is limited to that which has been granted to it under the Australian Commonwealth Constitution, the states have actually no limit in terms of their ability to pass a law on any subject matter for as long as it applies solely to a state, to its own state, or the territory within the state. And this is because even at the time of federation, it is understood that the state parliaments are able to exercise those same powers that it already had at the time when states were created in Australia, and subject only to the limitation as the states allow themselves to by providing the Commonwealth Parliament the ability to pass laws on particular subject matters. So as far as the state parliaments are concerned, there is no inherent limit on its ability to pass a law on any subject within the state. But so in other words, the state parliaments don't have to look for any source of power because it is understood that they can pass any law within its own state. But the Commonwealth Parliament must be able to rely on the Australian Commonwealth Constitution to establish its ability to pass a law on a particular subject matter. So that's a crucial point. Now, the moment, therefore, when the Commonwealth Parliament therefore passes a law, before we even talk about the question whether or not that Commonwealth law conflicts with the state law, we always begin by asking the question, can the Commonwealth Parliament pass that law? Is there a head of power on which it can pass that law? And if we recall, based on the engineer's case, given the expansionary doctrine that the High Court has now interpreted the powers of the Commonwealth Parliament, the Commonwealth Parliament is understood to have very broad and expansionary powers to be able to pass a law on any subject matter based, for example, on Section 51, even if the grant of power is not very explicit. So, for example, as we know, just as a reminder, for example, even if the Constitution does not provide the Commonwealth Parliament the power to pass laws, for example, on natural resources or in the natural environment or in relation to climate change law, the Commonwealth Parliament would be able to pass a law on those subject matters, for example, by citing its power under the Constitution concerning international powers or the defense of the Commonwealth. And in relation to that, if the Commonwealth Executive, for example, enters into a treaty that governs questions of in relation to climate change or the natural environment, then as we know, following the engineer's case, the Commonwealth Parliament will then be able to pass a law on that subject matter. Now, the thing, however, is that because we know state parliaments always have to pass laws in relation to a state because they need to regulate activities and their subjects within a state, there therefore is a very strong possibility that the laws passed by the state parliament will conflict with the laws passed by the Commonwealth Parliament. And in that case, when there is a conflict of laws between the laws passed by the Commonwealth Parliament and the laws passed by a particular state parliament, what then happens? And we're going to examine this in the context of Section 109, where the Constitution clearly provides that in the event that there is an inconsistency between the Commonwealth law, between the Commonwealth law and the state law, then the Commonwealth law shall prevail to the extent of the inconsistency. So, but it doesn't seem to be as simple as that because, number one, we need to know what laws are we talking about. And number two, we need to ask, what exactly does it mean? When is there actually an inconsistency? And thirdly, assuming that there is an inconsistency, what actually happens to the state law? Does the entire state law get invalidated? Or is there a way to by which the courts are able to harmonize what appear to be apparent conflicts in terms of the provisions of particular laws or laws between the Commonwealth Parliament and state laws? And so that's the focus of our of this particular lecture podcast. In next week, we're going to be talking about a different type of conflict, and not next week, but in 2 weeks' time. And we're going to be talking about what we consider to be horizontal conflicts. And that is, for example, on the ability of the Commonwealth Parliament to pass laws, and which in a sense may interfere with Commonwealth judicial powers. But that's going to be a different topic altogether. So in other words, when you look at Australian constitutional law, therefore, we're often dealing with conflicts of power. So power is exercised by the executive, by the parliaments, and by the courts, both at the Commonwealth level and the state level. And constitutional law is really about dealing with those particular conflicts, whether at the vertical level, in other words, between the Commonwealth and states, and at the horizontal level, between among the executive, the parliament, and the judiciary. So we're going to be looking at the horizontal conflicts of power, I think, in week 8. But for now, we're going to be focusing solely on the conflict of laws between the Commonwealth Parliament and the state parliaments. So after studying this topic, you should be able to discuss and explain the potential forms of conflict that can arise between Commonwealth and state laws, the contemporary approach by the High Court in identifying whether there is a conflict or not, and the constitutional mechanism for resolving a conflict of laws where it is found. So let's get going. Now, before we even dig deeper again into the issue of conflict of laws in terms of the laws passed by the Commonwealth Parliament and the state parliaments, we always need to be reminded that at the time of federation, what it practically meant was that the state parliaments had to surrender some of their powers in relation to the ability to pass laws in favor of the federation. And as we know, prior to the engineer's case, what it essentially meant was that the High Court was very cognizant of the need, in a sense, to protect the ambit of power of the state parliaments, because prior to federation, the states had supreme authority to pass laws on any subject that it liked, for as long as it applied solely within the state. And in fact, as we see later on in succeeding weeks, because of the principle of parliamentary supremacy, at least in relation to the states, the state courts don't even have the power to declare as invalid any law that is passed by a state parliament. So prior to federation, just like it is in New Zealand and in the United Kingdom, for example, any law that is passed by a state parliament prior to federation could not be declared invalid by a state court. That's how supreme the parliaments are. And that is true even today. So we will learn that there is such a notion as parliamentary supremacy, at least in the states, which means that state courts do not have the power to invalidate state laws. Of course, today, because of the Australian Commonwealth Constitution, although there is still the principle of parliamentary supremacy, there are now constraints to the power of the state parliaments to pass a law, because if they are in conflict with the Australian Commonwealth Constitution, then those laws will be invalidated. But for as long as the laws passed by a state parliament are not in conflict with the Australian Commonwealth Constitution, then state parliaments are supreme. They can practically pass any law that they wish in their states. So as far as the states are concerned, as I mentioned, state courts do not have the power to invalidate laws. It's quite different in general, as I said, because of the limitation imposed by the Constitution today. But it's quite different when it comes to the level of the Commonwealth, because there is no such thing as parliamentary supremacy of the Commonwealth Parliament, because given the fact that there are constraints because of the division of power between the Commonwealth and the states, plus the fact that, for example, when we look at the Boilermakers case in about 2 weeks, we will see that the High Court has been very emphatic and very rigorous in trying to assert its authority to police the ability of the Commonwealth Parliament and even the Commonwealth Executive, in its ability to pass subordinate legislation, and the ability of the Commonwealth Parliament to pass laws. So it will police it. Okay, so having said that, therefore, when we look at conflicts between laws passed by the Commonwealth Parliament and state parliaments, we always have to be mindful of the fact that there is a tension between Commonwealth parliaments and state parliaments in their ability to pass laws. And we also need to remember that these conflicts arise because of the inherent differences in terms of policies that each of these governments, the Commonwealth government and the state governments, may wish to prioritize. The states, of course, are very focused on their ability to, the state governments are very focused on ensuring that they win state elections. And so they ought to pass laws that would find favor among the electorate. And so their focus would be the states. And as we know, the laws passed by the state of Queensland, for example, are probably different from the laws passed in New South Wales and in Tasmania, because they all have different agendas, different needs, etc. And at the level of the Commonwealth, though, it's more concerned about what is good for the Commonwealth. So given the fact that each of these governments have their own policies, have their own political agendas, and the desire to stay in power, it necessarily follows that there will often be a conflict as far as the ability to pass laws is concerned. And to a great extent, therefore, we also need to remember that the High Court will continue to balance or find a way to navigate the tension between the ability of the Commonwealth Parliament and the state parliaments to pass laws. Because as we know, there are at least two levels of government that coexist. So we've got the Commonwealth government and, of course, the state governments. And so part of the key things that we need to consider always is in relation to the division of powers, and in trying to identify where the conflicts arise, and when those conflicts arise, how the courts are likely to navigate these conflicts or deal with them. Okay, so again, just as a reminder, the key reason why these conflicts exist is because, to a great extent, there is concurrent lawmaking powers of the Commonwealth and the states under the Constitution. As we already know, the ability of the Commonwealth Parliament to pass a law is strictly limited to that allowed by the Australian Commonwealth Constitution, in particular Section 51. But it doesn't mean that because the Commonwealth Parliament has a head of power under Section 51, it does not mean that the state parliaments are no longer able to pass a law on those same subject matters. In fact, practically all the heads of power over which the Commonwealth Parliament is able to pass a law on is also a field or a head of power over which the state parliaments can also pass a law on, except to the extent that it is clear that it is only for the Commonwealth Parliament. For example, the defense of the states, that's clearly a power that is exclusive to be wielded solely by the Commonwealth Parliament. Or, for example, the power to have naval forces, or the power to mint coins. So those are clearly exclusive powers that belong to the Commonwealth. And if you look at other provisions of the Constitution, the power to pass laws concerning excise taxes and duties are again exclusive to the Commonwealth Parliament. But in general, the Commonwealth Parliament and state laws occupy certain fields and areas over which they can concurrently pass laws on. And then that means, therefore, that there is huge scope for a conflict between these laws. And so we know, we're going to be looking at Section 109 further, because we know that under Section 109 of the Constitution, in the event that there's a conflict between a Commonwealth law and a state law, then the Commonwealth law will prevail to the extent of the inconsistency. Now, I already mentioned that when we talk about conflict of laws, we always ask what exactly are the laws for the purpose of triggering Section 109, and to that extent, we always ask ourselves that first basic question: is that particular law passed by the Commonwealth Parliament even one of those subject matters over which it can pass a law on? So before you even talk about Section 109, we need to be able to determine or establish that the Commonwealth Parliament does have the power to pass a law on that subject matter. And then if it does, and that Commonwealth law conflicts with the state law, what then happens? When we say this, for example, it doesn't necessarily follow that the litigants in a case involving constitutional law are always the Commonwealth Parliament and the state parliaments. Oftentimes, the litigant or the plaintiff or the applicant in a case involving constitutional law will actually be private citizens or private companies, or it could be unions, who are then trying to find a way to question the constitutionality or validity either of a Commonwealth law or a state law, because it might mean that as far as a private individual is concerned, or as far as a private entity is concerned, it doesn't know which law to follow, especially because the Commonwealth law may say one thing and the state law says another, both in terms of the rights that are conferred, or maybe in terms of the duties that are imposed, or even in terms of the penalties that may be imposed by a Commonwealth law and a state law. And in that particular case, what is a person or an entity, private entity, meant to do? And so we need to look at the law for the purpose of triggering Section 109, and we need to determine, when do we know that there is an inconsistency? Because we always remember that a basic law of statutory interpretation is that the courts will always try to find a way to harmonize laws passed both by the Commonwealth and the state parliament. So the courts will try to find a way by which a state law, for example, does not have to be deemed invalidated by a Commonwealth law because of some inconsistency. Is there a way, for example, and this is what we're going to see, is there a way by which an individual upon whom certain duties are imposed may actually be able to comply with both a Commonwealth law and the state law, even if there appears to be some level of inconsistency between these two laws? So that's what we're going to be looking at. When is there an inconsistency? And assuming that there appears to be an inconsistency, what then happens? Does it mean that the state law gets invalidated? So these are the type of conflicts that we're looking at. Okay. Now, as far as conflicts are concerned, we're going to be looking at the forms of conflict in a short while. But the other conflict will be, whether the conflict is direct, when the Commonwealth and state laws clearly directly contradict each other outright. So you see a clear inconsistency. But then you can also have an indirect conflict, where compliance with one law may mean that there is a possibility of breaching the other law. But in that sense, the contradiction or the conflict is not direct, or it's not even apparent. So in that case, what needs to be done? So an example of a direct conflict will be when the Commonwealth, for example, legalizes an action, but the state law criminalizes it. For example, we may recall that around 2016, I think it was the Western Australia, or was it Tasmania, which passed a law, for example, concerning same-sex marriages. And the Commonwealth Parliament went to the High Court to question the legality of the same-sex marriage law. So this was prior to the same-sex marriage law passed by the Commonwealth Parliament, I think in 2021. But in 2015 or 2016, Western Australia, or was it Tasmania, passed a law that allowed same-sex marriages. And so in that case, the state law clearly would have allowed same-sex marriages, but the Commonwealth wouldn't allow it. So in that case, what needs to be done? There appears to be a clear level of inconsistency there. Or it may mean that the Commonwealth law, for example, based on the same-sex marriage law in 2021, now allows same-sex marriages, and states may not allow it. So what then happens? So in that case, in the case of an inconsistency, what happens? We also know that in some states, I'm not sure if it's true today, there was a time when sexual behavior or sexual activities among people of the same sex was considered to be criminal. And so in that case, what happens if the Commonwealth passes a law that actually, recognizes same-sex marriages, and to that extent, therefore, there is a clear contradiction between a state law that criminalizes sexual activities between people who belong to the same sex, and then a Commonwealth law that clearly permits same-sex marriages, what happens? So that's an example. You can also have a scenario where there is a regulatory burden that is imposed by the Commonwealth, and then it conflicts with state law objectives. And we've seen this happen in many cases in the previous weeks when we talked about, for example, economic powers. Because on the one hand, for example, it could be the Commonwealth Parliament passing a law concerning consumer laws. And as far as the provisions of the Commonwealth consumer laws are concerned, they may be in conflict with the consumer laws passed by states. And in that case, these conflicts may mean that it may be quite difficult for a business operating within a state to be navigating the contradictions between these two laws. And so the question then is, what happens next? So we're going to be looking at those. So on the one hand, we're dealing with direct conflicts and indirect conflicts, but we're also going to be moving now to a discussion of the forms of conflict. So when we talk about a conflict of laws between the laws passed by the Commonwealth Parliament and state parliaments, those conflicts can arise in relation to duties, and we're going to be looking at examples in a short while. It can be in relation to conflicts of rights. It can also mean it could also be in relation to overlapping requirements, different penalties, and operational inconsistency. So let's have a look now at some of these conflicts. Let's look at an example of conflicts of duties. So where it may be said that it is impossible to obey both Commonwealth and state laws. So one of the cases, as we know, is Regina and the Queen and Brisbane Licensing Court, ex parte Daniel, which was a case decided by the High Court in 1920. So this was prior to the engineer's case. Again, it's important to remember that because when you see these types of cases, always ask yourself, did this happen prior to the engineer's case or was it after? Because that will give you a sense of the flavor of the court or the way by which it is likely to consider or approach conflicts between Commonwealth laws and state laws. Because as we know, prior to the engineer's case, which was, I think, passed by the High Court in 1933, what it essentially meant was that the High Court was very vigilant of trying to protect the power of state parliaments to pass laws. Whereas in 1933, based on the engineer's case, the approach of the High Court was to consider more broadly the power or the ability of the Commonwealth Parliament to pass laws, so that the doctrine became what is known as expansionary. So that it was for as long as, for example, under the engineer's case, for as long as the Commonwealth Parliament could show that there is a head of power over which it can pass a law, it practically meant that on the basis of that law, for example, in relation to industrial relations, it can then go into other areas which are not directly in relation to industrial relations, but may be considered to have a sufficient connection to it. So when the Commonwealth Parliament, for example, passes a law concerning industrial relations, it may then go into a subject matter such as health, or even a requirement about education, which are not clearly subject matters over which the Commonwealth Parliament has to pass a law. So just have this awareness about when a particular court case was passed. Now, in the case of Regina and Brisbane Licensing Court and ex parte Daniel, in this particular case, a state law conflicted with a Commonwealth electoral law, because in that particular case, there had been a Queensland state law that was passed, which required a referendum on liquor trading hours. But on that same day, there was a federal state election that was scheduled. And as we know, as we will see later on, under the Constitution, of course, the Commonwealth Parliament will have the ability to pass a law pertaining to the election of senators and members of the House of Representatives. So as far as head of power is concerned, it's not actually really limited to Section 51, but given the framework of the Constitution, the Commonwealth Parliament apparently or clearly should have the ability to pass a law concerning elections. And here you have a scenario where it is very difficult for a person to comply with both laws, given the fact that the Commonwealth prohibited voting on the same day for both elections, for the state referendum in Queensland and the federal state election. So it was impossible because if a person voted in both, voted in the state referendum and voted in the federal state election, because it is a legal duty to vote in a federal election, for example, it would have to mean that a person would be in breach of at least the Commonwealth law. And for this reason, given that this kind of inconsistency, which made it impossible for a person to comply with both laws, the state law was deemed invalid because of the inconsistency. And so this is a case where it established the impossibility of simultaneous obedience test, where it is clear that a person or an entity couldn't possibly obey simultaneously both a Commonwealth law and a state law, especially because doing so, trying to obey both laws, will mean that there will probably be a penalty that person will have to face based on a Commonwealth law. Now let's look at another form of conflict, and that is a conflict of rights. So here we're looking at the scenario where a Commonwealth law grants a right that a state law takes away. So for example, in Colvin and Bradley brothers, there was an inconsistency between Commonwealth and New South Wales laws regarding women's work in the metal industry. In this particular scenario, the Commonwealth law allowed women to operate milling machines unless they were specifically prohibited. So here, the Commonwealth Parliament, as far as its policy and agenda are concerned, they were, in a sense, more politically broad-minded, and they viewed that women should be permitted to operate milling machines, even if they may be deemed to be dangerous. So, that was a different generation then. This was 1943, just about a time when, World War II was really happening. And at the time when I think societal values were such that women were mainly to be staying at home. So that was a very different generation then. And yet, New South Wales law banned women from operating dangerous machinery, again, out of concern for women. So there was a conflict. So, broad-minded Commonwealth Parliament, and you've got states who felt that women shouldn't be operating dangerous machinery. Of course, that's no longer permitted today, right? And because there was an apparent conflict, the question then had to be, a question of covering the field doctrine. It began by asking whether or not the Commonwealth Parliament had the power to pass a law concerning, the ability of women to work in the metal industry. That by itself would, when it comes to the question of women working in the metal industry, and when we look, for example, at Section 51, it doesn't really talk about the ability per se of the Commonwealth Parliament to pass a law concerning industrial relations, but the ability of the Commonwealth Parliament to pass a law, for example, pertaining to arbitration and conciliation for the settlement of industrial disputes. But given the fact that there is that head of power that the Commonwealth Parliament could rely on for the purpose of passing a law concerning women's work, then it could be said that there was an attempt on the part of the Commonwealth Parliament to regulate regulate industrial relations, which includes women as part of the workforce. And therefore, given the fact that the Commonwealth Parliament clearly had a head of power on which it could rely in terms of passing this law pertaining to women's rights to work even in areas or domains which are quite dangerous, and then that the Commonwealth law clearly was in conflict with a state law, one based on the expansionary doctrine of the engineer's case, given the fact that the Commonwealth Parliament clearly intended to cover the field. It meant then that there was a clear desire on the part of the Commonwealth Parliament to legislate in this particular area, which meant that there was clear conflict between the Commonwealth law pertaining to women working in the metal industry and even operating milling machines. That was clearly in conflict with state law. And given the inconsistency, therefore, the Commonwealth law prevailed. I already mentioned the example concerning, same-sex marriages, where there is a conflict of rights. Well, in that case, the conflict prior to the same-sex law passed by the Parliament in 2021, but in 2015 or 2016, when a same-sex law marriage was passed, it essentially meant that the states, I think it was Queensland, no, rather, it was Tasmania or Western Australia, which allowed same-sex marriages. But in that particular case, the Commonwealth Parliament only, as far as the Family Law Act was concerned, only recognized marriages as being between men and men and women. And for that reason, because under the Commonwealth Parliament, under the Constitution, the Commonwealth Parliament had the power to pass laws pertaining to marriage, the Commonwealth law was therefore, the state law, which allowed same-sex marriage, was clearly in conflict with the Commonwealth law. And in that particular case, the High Court ruled that given the inconsistency between the state law, which gave people or individuals or citizens the right to enter into marriage, even if they belong to the same sex, that was clearly in conflict with the Family Law Act, which only recognized marriages between people of different sexes. Then the state law was deemed to be invalid. Today, of course, given the same-sex marriage law passed by the Commonwealth Parliament, it would be unconstitutional, for example, for a state law, for a state parliament to pass a law that would prohibit same-sex marriages or deny people of the same sex certain rights on the basis of the fact that they may be in a partnership or in a relationship, when they are of the same sex. That would be inconsistent with rights granted under the Same-Sex Marriage Act passed by the Commonwealth Parliament. So if there were a case where a state parliament passed a law that conflicted clearly or even indirectly with the same-sex marriage law passed by the Commonwealth Parliament, that state law would be deemed invalid because there would clearly be a conflict of rights provided or granted by the Commonwealth Parliament and rights apparently denied or limited by the state parliaments. Okay. Now, the other scenario we should be looking at is in relation to overlapping requirements, where, and as we said, state parliaments pass laws within their states, apparently, because they want to be able to regulate their subjects, meaning the people who live there, residents, citizens, and so on, entities, companies, etc. They want to be able to regulate activities and regulate subjects and regulate certain activities as well. And of course, as we know, as far as the Commonwealth Parliament is concerned, it is also legislating in relation to the same individuals, to the same entities, and over the same area. So the laws of the Commonwealth Parliament apparently clearly apply across the states, right? And so therefore, it is very possible that both the Commonwealth Parliament and the state parliaments will legislate in relation to the same field, or in relation to the same domain, or in relation to the same subjects, or the same activities. And when there is an attempt on the part of both the Commonwealth Parliament and the state parliament to pass a law, then there may be overlapping requirements, or there may be requirements where one is more stringent or more liberal than that of the other. And so in that case, what happens when the standard set by the Commonwealth Parliament is different from that imposed by the state law, or when a state or even the Commonwealth Parliament imposes additional or different requirements? So an example of this is the case of Australian Boot Traders, Trade Employees Federation and Wybrow and Company, a case decided in 1910. So again, prior to the engineers case. And in that case, the conflict was that the Commonwealth mandated a higher minimum wage, whereas the states established a lower minimum wage. Of course, today we now know that in relation to minimum wages is practically the Fair Work Commission, which is able to control minimum wages, mainly because it regulates industries and industrial relations. But at this time, in 1910, you had a scenario where the Commonwealth felt that minimum wages had to be higher, and as far as the state was concerned, the minimum wages for bootmakers were meant to be lower. So they were regulating the same industry and the same subjects. In that scenario, though, although there appeared to be some inconsistency, imagine the High Court, imagine the federal parliament saying that the minimum wage should be $20, and the state parliament says it should only be $10. In that scenario, if you are an employer in a particular state where the minimum wage was actually only $10, you would prefer to pay out the 10, because it's cheaper. But if you did, you'd be violating a Commonwealth law. So what happens? There appears to be some inconsistency, clearly, right? But here it's an unusual scenario, because although there appeared to be an inconsistency, the High Court found a way to say that there was no inconsistency, because it was possible for an employer in the bootmakers industry to comply with both laws simply by paying the higher wage. So if an employer in a particular state that mandated lower wages decided to pay the higher wages anyway, then it wasn't in breach of the Commonwealth law. And there is no penalty, there is no violation of a state law if an employer pays more than that which is required by the state. And so here, as we see, the High Court was able to find a way by which there was no inconsistency, even if there appeared to be some inconsistency. And the way the High Court navigated that particular scenario was simply by saying, well, there is no conflict, pay the higher wages, and you've complied with both the federal law and the state law. Of course, as far as the bootmaker employers were concerned, it's not a very happy scenario, because they would have preferred to pay the lower wages imposed by the states. But because of the mandate of the Commonwealth Parliament, they had to pay the higher wages. But this is a scenario where the High Court found a way that for there to be no inconsistency between the Commonwealth law and the state law, by having that almost artificial mechanism to avoid an inconsistency, by saying that an employer could simply attempt to comply with both by paying the higher wage. Another scenario involves the case of Clyde Engineering and Coburn, which was a case, again, decided in 1926. And again, this is the pre-engineers case. But here, you will begin to see the slow changes in the way that the High Court looked at conflicts between Commonwealth and state laws. In this particular scenario, there was a conflict between Commonwealth and New South Wales industrial laws, because on the one hand, the Commonwealth law set 48 hours as the number of hours per work week. New South Wales law, however, required a maximum of 44 hours. So clearly, there was an inconsistency. If an employer in New South Wales, for example, worked beyond 44 hours, so maybe if it required its employees, if it permitted employees to work for 46 hours, they would be compliant with Commonwealth law, but would be in breach of New South Wales law that was similarly trying to regulate the work week in the state. And again, if you look at this, theoretically, it was possible to comply with both laws by simply ensuring that an employer would make its workers work only for 44 hours. In that case, it complies with state law, which mandates a maximum 44 hours per work week, even if the Commonwealth allowed 48 hours. So this is a different scenario altogether from the first one, because here, if an employer in New South Wales were to were to force its workers to work for 46 hours, they would comply with Commonwealth law, but would be in breach of state law. In the other scenario we had, which was the case of Australian both Trade Employees Federation and WIBRO, it was different because it was the Commonwealth which mandated a higher minimum wage, and it was the state which established a lower minimum wage. And it therefore meant in this Australian Boot Trade Employees case, as I mentioned, that simply by trying to pay the higher wages, then in that case, the employer would be able to comply with the state award as well, which imposed a lower wage. Here, it's different because this time it is the Commonwealth which is saying that an employer is permitted 48 hours, but the state would only allow a 44-hour work week. So theoretically, there was it was possible to comply with both by just making sure that employers would only let their workers work for 44 hours. But here we now see that the High Court felt that the Commonwealth Parliament wanted to cover the field concerning the number of hours of work week. And because it intended to cover the field, it meant that the state parliaments could not pass a law pertaining to the same field in relation at least to the work week. And because of that, there was clearly therefore a contradiction or a conflict between the two laws. And because of the principle of covering the field doctrine, which we continuously see, especially in the engineer's case, the High Court ruled that the law passed by the Commonwealth, by the New South Wales Parliament was inconsistent with the Commonwealth law, and therefore, to the extent that the inconsistency was deemed invalid. So we've talked about different forms of conflict. We talked about conflicts in terms of duties, conflicts in terms of rights, and conflicts in terms of requirements that overlapped. We're going to look now at a scenario where there might be different penalties. So the conflicts arise because of different penalties imposed by Commonwealth and state laws. And in which case, therefore, both the Commonwealth law and the state law apply to the same conduct, or conduct that leads to the imposition of certain penalties. And in that case, where there is an inconsistency between penalties imposed by the Commonwealth and states, what then happens? So in the case of Hume and Palmer, this involved a conflict in penalties for breaching transport regulations, in particular, as far as boat captains were concerned in terms of navigation, in terms of internal waters. And so as we know, as far as internal waters of a state are concerned, they're similarly internal waters of the Commonwealth because they belong to the Australian Commonwealth. So you have on the one hand a New South Wales law relating to violations concerning regulations about collisions, and on the one hand there is the Commonwealth Navigation Act, and these two laws had different penalties. And in this particular case, this particular ship captain was prosecuted under the New South Wales law for violating collision regulations, but the penalties were actually higher and different than those imposed by the Commonwealth Parliament through the Commonwealth Navigation Act. And so therefore the ship captain argued that any criminal proceedings should not be based on New South Wales law, but on the Commonwealth law, because the Commonwealth law legislated on the same subject matter, and although it provided different penalties. And here, even though the captain had already been convicted by a state court for violating the New South Wales law, the High Court made a determination that the Commonwealth Parliament legislated in relation to the same field, so that you've got the covering field doctrine. The Commonwealth Parliament had the power to pass a law concerning navigation of internal waters. And in that particular case, therefore, because there was a clear conflict between the penalties imposed by the Commonwealth Parliament and the state parliament, then the Commonwealth law will have to prevail. And for that reason, the conviction of the ship captain under the New South Wales law was overturned. And the court ruled that any criminal proceeding could only be based on Commonwealth law. So we've looked at forms of conflict, including conflict of duties, conflict of rights, overlapping requirements, and then previously we talked about different penalties. We're now going to be looking at another form of inconsistency, and this relates to operational inconsistency. And here, the issue here is that it's actually possible, in a sense, assuming that you've got a law passed both with the Commonwealth Parliament and the state parliament covering the same field, it's possible in theory that both laws can coexist. And the question then is there a way for an individual who is subject to both laws to be able to comply with both laws, even if there appears to be some level of inconsistency? So an example of this is the case of Western Australia and Commonwealth pertaining to the Mining Act case in 1999. And so here, the conflict was that the Commonwealth had imposed restrictions on defense practice areas. And so there were certain areas, for example, in Western Australia, where the Commonwealth Parliament, or at least the Commonwealth, decided that there should be defense practice areas for the defense. But those areas were similarly areas over which the Western Australian government had granted mining exploration licenses. So in a sense, there was there was a clear clash in terms of the attempt on the part of mining companies who were trying then to exercise their rights on the basis of the mining exploration licenses they had, because when they went into certain areas, they may be in certain areas where there were restrictions imposed by the Commonwealth Parliament, because those areas were considered to be defense practice areas. And so therefore, in order, and as far as Western Australia is concerned, mainly, especially, of course, it relies so much on royalties and revenues coming from the mining industry. It wanted to ensure that the mining exploration licenses it grants to mining companies, for example, could be fully utilized. And here, so the conflict there, as we said, was that certain mining companies in Western Australia, which had been given mining exploration licenses, had clear limitations on their ability to venture into areas which had been declared or classified as defense practice areas by the Commonwealth legislation. So the question then is, given the potential operational conflict, what happens? And so we see here some complexities arising from concurrent powers. And how did the High Court rule in this regard? The High Court ruled that it was actually possible for both laws to coexist at the same time. So in other words, there was no inconsistency, simply because as far as the defense practice areas were concerned, there were restrictions, for example, in terms of the time or the particular areas where defense practices were defense exercises were going to be conducted. So outside of those areas, so for example, because this was based on directions that could be given by, for example, by the defense minister, if the defense minister said that the practice areas or the defense practices would occur, for example, only on Wednesday between 7 a.m. to 10 a.m., it then meant that in those same areas, then the mining companies could engage in mining exploration activities after 10 a.m. So although there appeared to be some level of operational inconsistency, it was possible to reconcile or harmonize these two laws so that the Western Australian law was still deemed to coexist and be valid, despite the apparent operational inconsistency. Although the one of the judges of the High Court noted that although theoretically it was possible to reconcile both laws, there was always the danger that at some point it was going to be practically impossible for a mining company to be compliant with both. But at that time, the ruling was that both laws could coexist. In other words, the Western Australian law was not necessarily in violation of or inconsistent with the federal law. So let's look at the final case now concerning operational inconsistency. And here the case is Momcilovic and the Queen. And here, again, you have a scenario where there's an attempt both on the Commonwealth Parliament and the State Parliament to regulate drug trafficking. And here the focus is on the issue of maximum penalties. Here in Momcilovic, yeah. My wife, she's calling. Okay, sorry about that. So here there is the High Court found again no inherent inconsistency because as far as the Commonwealth Parliament was concerned, it did not intend to fully regulate drug trafficking. And so here in this scenario, it allowed for concurrent operation of Commonwealth and state laws. The concern, though, of Justice Gamo in this particular case was that there was a possibility of operational inconsistency because if charges were pursued under both laws for the same offense, then clearly in that case, there would be an inconsistency. And so, but in that particular case, there was no inherent inconsistency. And so they could coexist despite the fact that there could be what is known as covering the field doctrine. So again, this is an attempt at finding a way to allow both laws to coexist. Found no inconsistency. Oh, that's human, Palmer. Okay, got confused. Okay. So we've talked about inconsistency. What then happens when we talk about consequences of conflict? So as a review, when there is an inconsistency between Section 109 of the Australian Constitution, if there is an inconsistency between Commonwealth law and state law, then we know that under Section 109, state laws are invalid to the extent that they are inconsistent with Commonwealth laws. So the state law is not invalid as a whole. It's only to the extent that they are inconsistent with Commonwealth laws. In fact, we know that when we look at the rules on statutory interpretation, for example, and we examine laws which are being passed in greater detail, we always notice that there is a provision in these laws that in the event that a law is passed and is in conflict, for example, with the Constitution, then that particular provision is severable to enable the other parts of the law to remain valid. So based on Section 109, it doesn't mean that if there is an inconsistency between Commonwealth law and the state law, that the entire state law is invalid. It only means that to an extent of the inconsistency, that inconsistency will be deemed to be disregarded, but not the entire law itself. And it's possible, therefore, for the High Court to remove the offending provision in the state law if that were possible, given a severability clause in the law. But of course, if the provision cannot be severed, then the entire state law may be rendered inoperative. So, for example, the law concerning same-sex marriage in 2016, and then the Same-Sex Law Act in 2021, in these particular scenarios, it may not be possible to save a law simply because of the gross inconsistency between the two laws. And of course, as we know, an inconsistency cannot be remedied retrospectively. So in other words, if there is an inconsistency and it's not possible to reconcile this inconsistency, it will probably have to mean that the state law that offends the Commonwealth law will have to be enacted again. So, in terms of review, we've focused on specific forms of conflict between Commonwealth and state laws as recognized by the High Court. And in terms of the contemporary approach, the current approach, of course, gives significant power to the Commonwealth to override state laws on the same subject matter, especially given the engineer's doctrine, which allows for an expansionary approach to the ability of the Commonwealth Parliament to pass a law. And of course, as well, we have the covering the field doctrine, that if the Commonwealth intends to legislate comprehensively on a particular topic or on a particular subject matter, then to a great extent, state laws on that subject are rendered inoperative under Section 109, at least to the extent of the inconsistency. And if it is evident that the Commonwealth intended to cover the same subject matter, even if it's not explicit, it's possible to see that there is an implied intent on the part of the Commonwealth Parliament to cover the field. And in that case, it would also mean that the High Court is likely to find any inconsistent law passed by a state to be invalid. And of course, as we know, that one of the mechanisms, at least two of the mechanisms by which these conflicts are approached by the High Court would be an attempt to look for a way to harmonize these conflicts, in the sense that the court will say that there isn't any apparent conflict because theoretically it's possible for an individual subject to the same law to comply with both, and we've seen that in the examples that we've talked about. As far as operational inconsistency is concerned, as well as to consider the fact that it may mean that it's possible for an individual to comply with both simply by complying with the higher standard, as we saw in the case where the Commonwealth Parliament said that the minimum wage was higher and the state law legislated a lower minimum wage, and the High Court said that there was no inconsistency simply because an employer could pay the higher wage and therefore be complying both with the Commonwealth law and the state law. And so when we therefore look at the laws concerning the doctrine concerning the conflict of laws, we always need to be mindful of the fact that at the end of the day, the High Court is very cognizant of the division of powers in Australia between the Commonwealth Parliament and the state parliaments. And it's also important for the High Court recognizes as well the need to, in a sense, to consider the conflicting policies and agendas of both the Commonwealth Parliaments and the state parliaments in trying to regulate and deal with the distinct needs of both the Commonwealth and the states. And so after studying this topic, you should be able to discuss and explain the potential forms of conflicts that can arise between Commonwealth and state laws, the contemporary approach by the High Court in identifying whether there is a conflict or not, and the constitutional mechanism for resolving a conflict of laws where it is found. Thanks everyone for watching this tutorial. Bye.